My name is Dale O'Neill. I'm an attorney in Fort Worth, Texas. I've been here 35 years or so, and today I'd like to talk to you about mediation. Mediation can be in a lot of formats, a lot of different kind of players, a lot of situations. Primarily, I do a lot of family law and probate and business litigation. I help mediate those kind of disputes. A husband and a wife, parent and child in probate, two business partners in business litigation. I try to act as a mediator, the go-between, to help them reach an agreement. And a little bit about my background. I've been a lawyer for like 35 years, as I've said, but the first 20 years or so, I went to trial every day. Every day I went to trial, and my one job was to help one side win, which by definition meant the other side I tried to make them lose. I did that every day for 20 years, and I told myself every day that I was helping someone. I was helping this one side. And at the end of that 20 years, I kind of reflected, and I didn't know if I was helping as much as I thought. And I developed a new definition of the word help. Help to me now means help stop the hurt, help begin the healing, helping people, helping families, helping business partners, helping relationships. And so the first 15 years, 20 years or so, I went to trial every day. And these last 15 years, I've tried to help every day. I've kind of gone from being a lawyer to a human being. I still have my law degree, still have my law license. In fact, I'm board certified by the Texas Board of Legal Specialization. I've got an L.L.M in taxation, which really comes helpful in probate cases and divorce cases and business litigation. I'm an adjunct professor of law, and when I train young lawyers, I try to encourage them to help people, and I try to give them my definition of helping people. Helping people now means resolving disputes, resolving problems, and that's different than winning for someone and winning a resolution and winning over somebody else. Let me tell you about winning in mediation. In fact, that's the topic of this video. This video has been approved by the State Bar of Texas. The topic is winning at mediation. And that's a bit of an oxymoron. Winning in mediation means resolution. Winning in mediation means minimizing your cost. Winning in mediation means minimizing your risk. Winning in mediation means you stop the emotional angst that you've been experiencing from day one. From the very first time you knew about the problem, the very first time you saw the legal papers, the very first time you talked to a lawyer, you've had this angst inside. Winning at mediation means resolving it, leaving that behind, and going forward. Quit paying the lawyers, quit having the angst, quit having bad dreams at night, just getting resolution, getting something you can live with. It doesn't mean victory. It doesn't mean punishing the other side. It doesn't mean showing that you're right, and it does not mean trying to win on every issue, every little issue. I see people do that in mediation. Mediation, the objective is to win and resolve the big issues. We're not going to resolve every tiny dispute. In a divorce, we're not going to resolve every pot and pan. We resolve retirement benefits and who gets the house and who gets custody. In probate, we don't resolve every little issue. That's not the objective. The objective is to focus on the big issues. We've got lawyers on the payroll trying to resolve these big issues. Let's focus on these big issues. That's what winning in mediation is all about. Now, a lot of people come to mediation and they believe they're going to win by winning the argument. And I'm going to tell you that I don't know if I've ever seen anybody in any situation win an argument. About what we can do is try to prevail. And by prevail, I mean the other side agrees with you. And you're not going to accomplish that by trying to win an argument. And in fact, I've given up trying to win arguments with people. Instead, I focus on now trying to win their trust. I'm not going to win an argument, but if I can win their trust, and if they trust in me, and they trust in the things I say, and they trust in my positions, then we're going to be more apt to settle. If they trust in you, then we'll be more apt to settle. If you trust in the other side. Now, and you may be thinking, I'm not going to trust the other side. You have no idea, Dale, what they've done, or what they've put me through, or what they've said in their papers, or what they said in court. You have no idea, Dale. I'll never trust that person again. Okay. Then in mediation, we try to put together a deal that you can trust. If you can't trust that other side, I'm going to try to put together a package that you can trust. The terms will be built in there, that you've got a backup plan, a safety net, a parachute to help to minimize the risk. And so we try to put together a plan that you can trust, a resolution that you can trust. Now, if you think the other side will never trust you, you might be surprised. I have found that if you'll come to the table and simply be honest, look them in the eye, tell them the truth, they'll begin to trust you. Sometimes that begins with admitting your faults. Now, your lawyer may tell you, don't admit your faults. That'll be used against you. Well, guess what? Everybody knows your faults. It's going to be used against you anyway. You might as well look everyone in the eye, admit to it, and this is important, apologize. If you want to settle a dispute, somebody usually has to take responsibility, belly up, admit what they've done, apologize for it, a sincere apology, and see if we can get resolution. Once you've done that, you've gone a long way to winning their trust. Once you win their trust, you have a greater chance of settling this dispute. And the other way of building up trust is building up trust just in the offers you make. Be realistic in the offers you make. You can offer to pay a penalty. You can offer to pay a penalty if you don't abide by the agreement. We're going to reach an agreement that you're going to pay so much money. If you don't, there's a penalty. You can build up trust by making offers that are fair to both sides. If you make an unfair offer, it's blatantly unfair, it's obviously unfair. The mediator tells you politely before they take it to the other side, I think this is unfair. The mediator will take the offer to the other room. It's not going to help. And in fact, it'll diminish the trust. And the less trust there is, the less chance of settlement. And when I say fair, we have to decide, what is fair? We have to decide kind of our best case and our worst case scenario. So before you come to mediation, I'm going to suggest that you get very familiar with all the facts of your case, all the values of the assets, all the legal positions, what does the law allow, what does the law prohibit in your particular case, and come to an understanding and a definition of your best case if you were to go to trial. What's the absolute best resolution the judge or jury can give you and your lawyer? And what's the worst that can happen? If you go to trial, what's the worst that the judge or jury could do to you? And so once you and your team have sat down, gone through all the issues, all the facts, all the law, and once you and your team have an understanding, a grip, an evaluation of what's the best case scenario and your worst case scenario, then you can really begin to approach this mediation with a higher chance of success. Because you've got to know your best case scenario and your worst case scenario so that you can assess the risk of litigation, assess the risk of not settling. You've got to factor in a bunch of things before you can make that risk. Before you can make that risk assessment. You've got to know the cost of litigation. you've got to look your legal team in the eye and just ask them, hey guys, how much is this going to cost me? How much is this going to cost our family if we don't settle? How much will it cost to pay you to lawyer up and go to court and represent me on this divorce or on this contested probate issue or on this business litigation? And who's going to pay it? Does the estate pay it in probate court? Do I pay it? Does the winning side pay it? Do I pay up front? You've got to know those things so that you can do a risk assessment, your best case, your worst case scenario, and you got to put a value on how much is it going to cost me if we don't settle in mediation? How much are my expert fees going to be? How much are the deposition fees going to be? And you factor all that in when you do the math in settling your probate case or your divorce case. Now, all that can be put in written form, black and white, get a calculator out, and we can do a mathematical assessment. But let me tell you, the biggest thing that will never be written on that piece of paper is the emotional cost of not settling. Most of the time, when you go to court, especially in family law, probate, or business litigation, you know the other side. You've got some sort of relationship with them. They can be your spouse, about to be ex-spouse. You could share the same grandma or grandpa, and now we have a will contest, see who's going to get the farm. They could be your former business partner who you trusted, you invested with, you created a business, you built things up, and now you're dissolving that business. Sometimes we fail to factor in the biggest cost of going to litigation is both our emotional angst, the wear and tear on us, and that relationship that'll forever be damaged if in fact you don't settle. And of course, nothing's going to settle unless it's fair. Now, your definition of fair may be different than mine, and the definition of fair may be different to the judge or to the jury. So if you know your best case scenario and you know your worst case scenario, fair is going to fall somewhere in between those. You know, to be fair to the other side, they're not going to give you more than your best case scenario. And to be fair to yourself, you're not going to take less than your worst case scenario. Now, I know that sounds pretty obvious, but I see offers made every day that are outside those boundaries. And so I see people come to mediation and their very first offer is outside those boundaries. They either offer the other side less than the other side would get in their worst day in court, or they ask for more than they know they'd ever get if they got their best day in court. I'll give you an example. If it's a business dissolution and one partner is going to get the business and the other partner is going to get some money, and maybe we kind of believe in our heart that the business is worth $500,000. That would assume one of them is going to get the business and pay the other one $250,000, half the business. I can't tell you how many times I've seen someone show up, a sophisticated businessman. They're in a business relationship with obviously someone they thought was smart enough to help them run a business, and they'll make an offer that does nothing but offend everyone. I've seen them make offers of, I'll take the business and I'll give you $50,000. Now, all they've done is destroy the trust, destroy the relationship, and impede the mediation process. If they'd sat down and done their best case and worst case scenarios, they know they're going to have to pay more than $50,000. And so when you offer less than you know is fair, when you offer outside that range of best case and worst case scenarios, you're not helping yourself. If you're there to actually get resolution, get a document signed, get a deal done, make your offers in between that best case and worst case scenario and work up that best case, worst case scenario before you ever come to mediation. Now, you can be creative, and that sometimes helps. You know, we have a best case, worst case scenario. Let's say it's a divorce, and they've got $500,000 in a 401k, okay? And everybody assumes, or maybe some people assume, they're going to get half the 401k or $250,000 of 401k money. You can be creative and say, well, look, instead of giving you $250,000 of pre-tax 401k money, I'll give you $185,000 cash, tax-free. That you can have the money now rather than getting 401k money that when you cash in, you've got to pay ordinary income tax on, and because of your age, you'd pay an early withdrawal penalty. So that may fall below the best case, worst case scenario until you factor in all the factors such as tax consequences and timing of the money, etc. A lot of times you can be creative simply using a timing issue. Let's say it's a probate case and you've got a farm. That's all you've got. But it's a significant farm and we all agree it's worth $500,000. If one side has the financial ability, they can just tell the truth. I know it's $500,000 and I know you're entitled to half, $250,000. I'm entitled to half, $250,000. We can sell it. And 2 years from now, hopefully, it'll sell. We'll pay realtor's fees. We'll pay the property tax between now and then. And you'll get your half and I'll get my half. Nothing could be fair. Or I'll give you $200,000 now. You don't have to wait 2 years. You don't have to pay property tax, and it's cash. I can guarantee it. I can pay you within 10 days. Now that may actually fall outside the best case, worst case scenario, but there's an inducement in there to make it fairer than just a mathematical calculation. So what is fair? I find that most lawsuits, whether it be family law, probate, business litigation, virtually any type of lawsuit, most disputes, most arguments fall into one of three categories: legal rights, valuation issues, or a power struggle. Now, let me repeat that. Most disputes, which lead up to lawsuits, fall into one of three categories: valuation, legal rights, or power struggles. Let me give you some examples. Legal rights. Are you entitled to inherit 1/2 of the farm or 1/3 of the farm? That's a legal right issue. Mom died. Was the farm her separate property or was it community property? That's a legal issue that determines the rights of some of the heirs. Legal rights. Am I entitled to 1/2 of the actual farm or am I entitled to 1/2 of the value of the farm? Last will and testament may determine one way or another. Legal rights. Am I legally entitled to spousal maintenance if I file for divorce and get a divorce? Am I legally entitled? It's a legal issue. Am I legally entitled to 1/2 the profits in this business? My partner and I are going to have a lawsuit and determine who gets what. Am I legally entitled to 1/2 the profits in this business? Am I legally entitled to prevent my business partner from selling his half to a third party? Does that violate some sort of buy-sell agreement? It's a legal issue. Am I legally entitled to prohibit my business partner from selling an asset? Those are legal issues. The other aspect I find that creates a lot of disputes, that leads to litigation, is valuation issues. In a divorce, what's the value of the stock options? What's the value of the pension? What's the value of any significant asset? Probate, what's the value of the farm? In business litigation, the ultimate, what's the value of this business? What's the value of this business if my partner is free to leave and compete against me? What's the value of this business if we sell it on the open market? So there's legal issues, valuation issues, and there's just old-fashioned power struggle. Some people call it turf. Some people call it third grade. It's a power struggle. And I find that that is the biggest cause of most disputes, especially in probate and family law and business litigation. It's a power struggle. So in probate, the biggest power struggle I see, the one that comes right up the forefront, is who's going to be the administrator or the executor of this estate. Grandpa died, who's going to handle things? Who's going to manage things? In divorce, it's a power struggle of who's going to make the educational decisions for our children now that we're getting a divorce. That's an example of a power struggle. Business litigation. Who's going to run the business and collect the monies and pay the bills and answer the phone from now until the time it sells? Who's going to list the farm for sale? Who's going to list the business for sale? And I find the best way to resolve power struggles is to actually dig down and find out what's really going on underneath and remove that issue by addressing the decision now. Let me give you some examples. People phrase it of Grandpa died, who's going to be the executor or the administrator? In other words, who's going to be the person that kind of runs things and makes decisions, who gathers up all the property, who distributes it to the heirs? Who's going to be the executor or the administrator? When I find out the real issue, mediation, I go back and forth, and I find out the real underlying issue is we don't trust the other party. We think that they've got a friend who's a realtor. They want their realtor friend to list the farm. We all kind of agree that the farm should be listed and sold in probate court. The question is, who's going to be in charge of deciding who the realtor is going to be, the listing price, etc. And the way we address that is, in mediation, is I really don't care who the executor or administrator is as long as we can define the terms. Either side can be the administrator or the executor as long as. Has to be a neutral real estate agent. Real estate agent has to be approved by both sides. We have to have a minimum listing price. Every party gets notice and knowledge and copies of any offers made by any third parties. So if the neighbor across the street wants to buy the farm, we're told about it. If an investor from New York wants to buy the farm, we're told about it. If you want to buy the farm, we're told about it. And we have an agreement that we cannot sell for less than X number of dollars. And when we build in those kind of terms, and we have that safety net, then most people say, yeah, the other side can be the executor as long as they meet these requirements, and as long as I get to match any price made by a third party. And so we resolve the real issue. Who's going to sell the farm and for how much? And we've dodged the fight about the label or the power struggle of who's going to be the person that signs a piece of paper. It doesn't really matter who signs a piece of paper as long as it has all those terms in it. A lot of times in divorce, in child custody, we have power struggles that can be resolved by looking at the underlying issue. Somebody says, I want to be the custodial parent that makes the educational decisions regarding the children. Okay, what does that mean? Well, I want to decide where they're going to school and things like that. A lot of times we can resolve that simply by saying things like, well, if there's a dispute and you live in two different school districts, because most of the time your children are going to go to school wherever a parent resides. If we live in two different school districts, what if we choose we look at the state of Texas charts, and whoever lives in the best school district, the highest rating according to the Texas Education Agency, that's where they're going to go to school. If there's a dispute about public school or private school, usually one parent versus the other has a greater ability to pay. Whoever pays for private school gets to determine where they're going to go to school, which private school. And that gets us past the power struggle, because if the power struggle is not about the name, I have custody of these children, the real power struggle is where are they actually going to go to school every day, Monday through Friday. And so I think you get the idea about the power struggle. We're going to really resolve the underlying issue. And I find that when we resolve the underlying issue, most issues go away. The labels and the titles and the power goes away. Now, let me talk to you about getting ready for mediation and some practical things. What to bring. If it's a legal issue, just talked about legal issues, bring whatever documents you need to make a prima facie case. And all that really means is bring whatever documents you have, whatever proof you have, whatever photographs you have to show that you're legally entitled to whatever you're asking for. So if you think Grandpa's will gave you the farm, bring a copy of the will. If there's a dispute and the last will and testament says that Grandpa gives you the 460-acre farm, but the farm may have 510 acres, bring all the documents you have, the last will and testament, the plat of the farm, anything you've got to show how much actual acreage is in the farm, any document that you can find whatsoever that'll help us settle that case. In family law, what I find is people fail to bring the most recent documents showing the valuation. I talked about legal issues and valuation. They fail to bring the most recent documents showing the valuation. Bank statements, 401k, pension plan, appraisals on real estate, whatever it may be. Bring whatever documents you have to show any and all of those things. If it's a business, maybe there's a buy-sell agreement. The most recent profit and loss statements. Anything you've got to show that'll help us show valuation or legal issues, bring anything and everything you've got that'll help us settle this case, because these are information things. Remember, go back to trust. Well, I don't think that's an accurate number. Well, here's the document they brought me. It's dated last week, and it looks like it's an official bank statement. So we don't really have to trust them on this issue. Here's the actual document. Here's the last will and testament. Here's what it says on paragraph 3. We don't have to trust them. Here's the document. So bring anything and everything that'll help you establish either a valuation or a legal claim. And the single most important thing that I'd ask you to bring, and a lot of people don't bring it, I'll never know why, please bring a written proposal. When you sit down, within the first 5 minutes, I'm going to introduce myself. You come to me for mediation, and we're going to talk and make eye contact, and I get to hear your voice, and you get to hear my voice, and we won't be together very long, and I'm going to say, either to you or to the other side, do you have a proposal? And if you want to verbally tell me that, I'll get out a legal pad and I'll write down everything you say, or you can hand me a written proposal. And I'm going to suggest that usually, not always, but usually, whoever presents a written proposal first has a better chance of accomplishing their goals. A written proposal that you make is going to show what you want to accomplish, what you want to receive, what you want in settlement terms, and it's going to set the terms. So what you may be debt adverse, and so you're willing to give up a little to get less debt. You may want the farm, and so you want the farm and you're willing to give up something else to get the farm. You may want the farm sold, and the first line is sell the farm. You may want more than 50% of the estate, the marital estate or the probate estate. The first line might be, I want 55% of the entire estate. And so whoever has a written proposal usually has a better chance of accomplishing their goals. Now, of course, you can't do a written proposal until you've done the things I've already discussed. Look at the issues, best case scenario, worst case scenario, etc. And we've done all that analysis, the valuation analysis, the legal issues, etc., the costs of litigation. And you do the best case, worst case, and you factor in the risk, then you can make a written proposal. Hopefully, you've got a written proposal that you can hand me within the first 5 or 10 minutes of mediation. Now, the way the mediation works, once we get that first proposal from one room to the other, is we go from offers to counteroffers, and I go back and forth usually. In most cases, I don't do a joint session. I find that it's counterproductive, in fact, harmful sometimes, for me to sit down with everybody if they're in litigation with lawyers and there's pleadings and discovery and everything else. We sit down and everybody wants to justify their position. And so usually, I go back and forth making offers and counteroffers. I visit with you, and then I'll leave you and go visit with them, the other side. And when you make an offer, I'm going to ask you simply make an offer. You don't have to justify your offer. And in fact, the justification process usually, not always, is usually detrimental to the actual settlement of this litigation, settlement of whatever dispute you have. And the reason is we get lost in the justification process. Whenever you justify your position, psychologically, the other side has to defend their position. They feel like they've got to respond. And in fact, they feel like if their lawyer does not respond, their lawyer is not lawyering. Wait a minute, the other side said something that's not true. I want to address that. You don't have to address it. What's your counteroffer? This is their offer. What's your counteroffer? Because we don't want to get lost in the justification and the defense of positions. Let me give you some examples. This is the kind of things I hear on every day. I should inherit more because you've already got everything you need in life. I don't. Therefore, please, I think I should inherit more from Grandpa's estate. Or, I should get more in this divorce because you blank. Fill in the blank with whatever you want to fill it in with. I should get more in this divorce because you blank. I should make the educational decisions about our children because you've always made all the decisions. All throughout the marriage, you always made all the decisions. Now it's my turn. I want the right to make educational decisions for these children. I should get the business, and I should buy you out. You don't need this business. You can always go to work for your family's business. I should get this business. I'll give you some money. You go to work for your family's business. And when the other side hears those things, they've got to defend the positions rather than respond to the actual offer. Yes, I've got all I need. It's because I worked harder. So you think you should get more of the marital estate because I was blank. So you're saying that you were perfect throughout this entire marriage? Yes, I've always made decisions regarding the children because you never cared. And now you show up in a divorce and now suddenly you care. I'm not going to let you make those decisions now. I've always made them. Yes, I could go to work for my family's business, but my family's business is losing money and it's the type of industry that's actually going into decline. And so suddenly we're talking about family businesses that aren't related. We're talking about making decisions that usually aren't really made, talking about who's going to make educational decisions. Most kiddos go to public school. And so we get lost in the defense and the justification process. Therefore, I'm going to ask, whenever you make an offer or a counteroffer, you simply make an offer. You don't have to defend it. You don't have to justify it. And remember, I'm not the judge. You don't have to convince me. All we have to do is convince them to sign it. You don't have to convince me. So don't focus on the why. Don't focus on the past. Don't focus on being right. Don't focus on winning every legal argument. Every little argument, every legal argument. Don't focus on that. I'm going to ask you, if you really want to settle this dispute, if you want to settle this litigation, I'm going to ask you to focus on the future. I'm going to ask you to focus on the resolution. I want you to focus on minimizing the cost, minimizing your risk if you go in trial with a judge or a jury, minimizing the emotional angst that you're going through. If you're in the middle of litigation and you're watching this, you've got emotional angst. You're looking for answers. You're looking for wherever you can find an answer. The answer is in settlement, not in reliving the past, not in winning the past, not in punishing whoever you're doing business with. If you want an answer, the answer is in settlement and compromise and resolution. Now, as we go through this process of this offer and counteroffers, sometimes there's a chance that we can settle some of the issues. A lot of cases have multiple issues. Grandpa died, and there's a farm. Yeah, there's a farm, but there's a lot of other issues too. There's the 1957 pickup truck in the barn. One side thinks it's a classic, the other side thinks it's a junker. There's a lot of smaller issues, but if we'll focus on issues and break down these issues, we'll have a much greater chance of success. And what I have found is if we can begin by agreeing on as many issues as possible, we'll have a greater chance of success. So let's say there's a 1957 pickup in the barn. One side thinks it's a classic, the other side thinks it's a junker. Well, let's just sell it. Okay, we can agree on that. I'll write that down. You may not sign it yet, but we'll write that down. We're going to sell the 1957 pickup that's in the barn. Now we can talk about the farm. And I find that the more we can agree on, and the more we can nod our head yes, then the greater chance that we're going to keep reaching an agreement as we go down our chart. And if we can't reach an agreement on all issues, then at least we've got an agreement on some issues. Now, different lawyers have different techniques, and there's different strategies in every lawsuit. There's different strategies in every dispute, and some lawyers don't want to do a deal on some issues unless there's an agreement on all issues, which I understand. Legally, if we reach an agreement on some of the smaller issues, then they may not be relevant and may not be admissible into evidence in trial on the bigger issues or on the unresolved issues. So just because we can't reach a partial agreement doesn't mean someone has done something wrong or they're being obstinate or hard to get along with. It may just be legal strategy, and that's what the lawyer's there for. That's what they're getting paid to do. But sometimes I find that we can reach an agreement on virtually everything, and we get down to one last issue. And I see this all the time. We reach an agreement on everything, and I'm excited. I begin to draft an agreement. I think we've got an agreement in a divorce on the children and child support and child custody and division of the assets, division of the debts, etc. I'm excited in a probate case. We've reached an agreement on who's going to be the executor or the administrator. What are we going to do with the farm? What are we going to do with the 1957 pickup? And invariably, somebody says, oh, there's one last thing. What's that? And they tell me, and it's something I haven't heard all day long. And so we've reached an agreement on all these issues, and now at 5 o'clock, they want me to go to the other room and ask for something that the other side has never heard before. Okay? And it's pretty common, and it can be very problematic. And so when I take it to the other side, it sometimes defeats the entire mediation. So if you've got something you want, put it in that first offer. If you wait till 5 o'clock to bring it up, sometimes it can torpedo the whole day, and the whole day is lost. All the money you've paid for mediation, the lawyer to sit there, the other side's lawyer, etc., can be lost because you brought up, or the other side has brought up something at 5 o'clock. Now, if the other side brings up something at 5 o'clock and you really want to get this deal over with, there's a couple of responses that you can give that are logical. They won't be offensive. They won't necessarily torpedo the whole deal. You can honestly say, well, I haven't heard that today. If I make that concession, what are you willing to give me in return? And the other side says, wait a minute, why do I have to give you something? Well, it's the first time I've heard it, and you're asking for something. Do I get something in return? Another response can be simply, okay, put it all in writing. If that's what it's going to take to get the deal, put it all in writing and have them sign it. Because I don't want to hear any more, just one more thing. Just one more thing. 5 o'clock, just one more thing. 5:15, just one more thing. Whatever it is, I want to know the whole deal. And if they're willing to do it, then just have them sign it. And we see if we can get it done that way. Make the first offer. Incorporate everything in there that you want, please. It'll help us actually settle the case. Don't ask for something at the end of the day that no one's heard about all day long. Now, if you really want to settle this case, and most people do, there are some things that you should avoid. I call them deal killers. You got to avoid these things. Number one, moving the wrong way in the negotiation. So you've got a $500,000 farm, and you offer the other side $200,000. They say no, and they come back with a counter. And your response is, okay, then I'll give you $195,000. What? That's a deal killer. You moved in the wrong way. Odds are, especially with an aggressive lawyer on the other side, they simply stand up and leave and mediation's over. You went from offering $200,000 to $190,000, $195,000, they stand up and leave. They assume that the message you're trying to send is, it's not going to get any better. So the other side stands up and leaves. It's a deal killer in negotiation to move the wrong way. Now, a lot of times what I see, people move the wrong way and don't know it. Let me give you an example. Business litigation, two business partners. Divorce litigation, husband and wife. Probate litigation, two heirs. They speak between themselves informally and don't tell their lawyer. Husband and wife. He says, well, I'll give you $600 a month in child support. She says, I'll think about it. She reflects, says no, and they go to mediation. Neither side's ever told their lawyer about that informal offer, and his first offer is, I'll pay you $400 a month in mediation. She explodes. Lawyers are bewildered. And so a lot of times, informal settlement conferences between the parties that don't include the lawyers can unknowingly torpedo the whole mediation session, because if the first offer moves the wrong way from what the people have talked about informally, people get their feelings hurt, people get angry, they lose trust, and the deal's off. It's a deal killer. The other deal killer I see is when, forgive me, but when the lawyer's ego overrides the settlement offers, the settlement possibility. The lawyer knows in his heart and in his ego he can do better than that in court. And he or she wants to say, no, let me take this to court. Please let me take this to court. I want to just crucify the other side on the witness stand. Please let me take this to court. Well, the only one that wins that sometimes is the lawyer. And they're not trying to do it just to win. It's just in their heart. They see that they can do more for you in the courtroom. Lawyer, please, I'm going to ask you, rein in and let's just see if we can settle this case. You can tell the client the truth. I can do better for that in court. We can put that in a written document. Client understands that this lawyer believes they'd get a better result if they pursued litigation. But the client decides and chooses to act against the advice of the lawyer and settle and compromise this case, this litigation, against the advice of the lawyer, and take less rather than go to trial. And so the lawyer's protected, the client gets what they want. The other thing I see as far as a deal killer is when one side says to the other side, if you don't settle this case, then I will blank. You can fill in the blank with all kinds of things. I will subpoena your girlfriend to divorce court. Well, just subpoena away. The whole world knows about it anyway. If you don't settle this child custody case, I'll have these children be interviewed by the judge. Well, okay, they're my children and your children, so both our children be interviewed by the judge. If you don't give me this farm in this probate litigation, then I'll do nothing to try to settle this case again, and I'll run up these fees, run up these costs, and I'll outspend you. All of those things are deal killers, and they're not going to help settle this case or accomplish your goals. Once again, please just focus on resolution. Now, there are other deal killers that we see both in litigation and kind of in life, at the workplace or in the family. And that's people seeking righteousness, people seeking justice. They want the world to know how they've been wronged. They want the world to know what the other side did. And they've got a great opportunity in mediation to settle the case, but they decide, well, I can't do that. If I settle this case, I can't put them on the witness side. And the judge will never know how bad they are. The judge will never know how good I am. Well, let me tell you, this judge probably has 1,000 cases on their docket. And while they may be the best judge in the world, they personally don't care. They don't care that your other side wasn't the perfect spouse. They don't care that you're the perfect spouse. What they care about is getting resolution, something that's fair, something that's agreed upon, and a signed decree of divorce, and we all go home. The probate judge may not care that you're the only one that went to grandpa's house for Christmas dinner, and the other side never came, never sent a Christmas card, never did a doggone thing. Judge doesn't care. There's a last will and testament. They care about resolution and getting that probate file closed. The probate judge does not care. They could be the best probate judge in the world. Yes, you're the only one that ever visited in the nursing home. You're the only one that ever actually gave them a bath. You're the only one who actually did anything for them and made them feel loved. Okay? But there's a last will and testament, or there's a statute about who inherits what. And yes, you want to tell your story, and you're probably right. The other side has their story too. You're better off, I promise you with all my heart, you're better off getting resolution, getting it resolved, getting a signed agreement, and closing the file, and closing that chapter on your life. Let me talk about other deal killers in mediation. That's when people show up at mediation with brand new information they've never shared with the other side. Let's say we're in probate court and we're arguing about the farm. We've had appraisals done on the farm. We've had a surveyor do a plat. We've done all kinds of things. We've talked about who's it best to list the farm with, et cetera, and we show up for mediation, and the other side says, well, I've done some research, and it turns out this farm is not part of the estate. Grandpa put that in the trust 20 years ago, and we just never knew about it. Or that's not part of the estate. That was purchased prior to marrying the decedent. That's somebody else's separate property. That's not part of the estate. Showing up with brand new information is a deal killer. If you've got information that needs to be shared, please do it before the mediation, or at the very least, at the beginning of mediation. A lot of times, brand new information is a deal killer. The other thing that can break down the mediation process is when you treat mediation like it's litigation. It's not litigation. It's not a discovery process, although you'll find out a lot of information. And it's not a process where we're trying to convince anybody, especially the mediator. It's not litigation. It is resolution. It is mediation. A lot of people treat it like litigation, and they personally attack the other side or the other lawyer. That's not going to help us settle. You can do those things in litigation in the middle of a courthouse. There's a great big courthouse with a very nice judge, and that's the place to do those kind of things if you want to personally attack someone. Does not work in mediation. That's a deal killer. So our objective in mediation is to see if we can get resolution. Do that by beginning with trust, if we can get it, either in the parties or in the terms of the agreement, the valuation, the legal issues, the power struggles. Do everything in our power to try to settle this case. Some people are tough to work with. Psychologists call those kind of people high conflict personalities. They're just difficult to work with. We can't get their trust. We can't agree on valuation. We can't agree on legal issues. We can't agree on the power struggles. They're a high conflict person. And you've seen people like this. They'd rather argue than agree. If you say yes, they're going to say no. You say left, they're going to say right. They're high conflict. A lot of people, because of their childhood or whatever issue is, they want to argue, they don't want to agree. They're happier if they're in a fight. And in fact, I've known people, their method of communication is fighting. I've seen people not want to get a divorce because they're so used to fighting. They'd rather drag out the divorce, the litigation, because that's their method of communication. If they're not in that fight, they don't know how to communicate with each other. Those are called high conflict personalities. And let me tell you, if you're on the other side and you're dealing with someone who's a high conflict person, let me make some suggestions about how to deal with that person, or if the lawyer's that way, to try to help settle this case and have a successful mediation. The first thing you have to do is sincerely listen to them. So I'm not saying, let them speak and you'll sit there and you'll endure it. Listen to them, whatever it may be. If I'm the mediator and I'm dealing with a high conflict personality, I know to settle this case, I've got to actually listen to that person, whatever it is they want to say. I've got to listen to it. I've got to empathize with that person. I've got to find out what's going on in them and actually care. And I have to say things, and you may have to say things like, I see your point. I can see why you would take that position. You've got to affirm that person. So you've got to listen, emphasize with them, and affirm them. I see you've got a good point. I hadn't thought of it that way. Let me write that down. And you've got to sincerely listen. And let's presume that everything they're doing is going in the wrong direction. We've got to turn that person and steer them towards settling. So we've got to take them away from the past and point them towards the future. And so when they tell you how good they are and how bad the other side is, we've got to say things like, you're right, I see your point. Let's get a divorce so you don't have to deal with that person anymore. When they tell you they're the only one that went to Grandpa's house, they're the only one that gave Grandpa a bath, I think you're right. I see your point. Let's get this over with. Let's get this estate settled in probate court so that you're free of them and you don't have to deal with them anymore and they're out of your life. The other kind of person you may have to deal with in mediation is a person who cannot make a decision. Some of you may be getting a divorce because you're married to someone who cannot make a decision. You may be ending a business relationship because the person you're in business with cannot make a decision. So, as we're wrapping up mediation, as we're getting near the end of the day, and there's been some good offers made back and forth, and it's time to sign, and when the other side says, and I've heard it, I just don't know. I don't know if I can sign this. I want to think about it. Well, they've got the legal right to think about it. And if we leave and they don't settle, then no one's bound by anything. That offer's not binding on the person that made it. But to try to settle that case at that moment, here are some suggestions I'd like to make to you. When you're dealing with a person who can't make a decision, say you're their lawyer, just sit down, piece of paper, and write down all the pros of settlement and all the cons of settlement, the good and the bad. Write down all the risk. Write down the cost of litigation. Write down the best case scenario and the worst case scenario and let them graphically see it. And then we go back to a mediated settlement agreement, hopefully a final document, and ask them, well, this is the good and the bad. This can happen if we don't settle. Now, this is what we're giving up if we settle, but this is what we're risking if we don't settle. And ask them if they want to sign this and get this over with, resolve this issue, quit paying lawyers, get out of this risk, get out of this litigation, no more depositions, or do we want to proceed forward? And I have found that that technique usually, if it's anywhere near fair, and if you believe it's fair for your client to take it, that technique settles most cases. Now, I've talked about deal breakers. Now I'd like to talk to you about deal makers. Please be kind. I know that you're probably hurt. You feel wronged. You feel like you're the good guy and the other person is the bad guy, no matter what the scenario is, but please be kind and understand they feel the same way about their position. It's not going to help to be unkind. I'd ask you to be respectful. They've got a position. They've got a lawyer. There's a judge. Let's please be respectful. If the other side's not respectful, I understand that may be why you want a divorce. That's why you want to end the business relationship. But please, on our end, let's be respectful. That'll help settle the case. To keep going forward and trying to get a deal, if at the end of the day we're real close, but we feel like we just can't get there. Rather than everyone leave, somebody please turn to the mediator, or maybe the mediator will offer to make a mediator's proposal. They've been in both rooms. They know what's important to both sides. They know what the trigger points are, the pressure points, and so they know where to maybe give a little here and take a little there and see if we can meet somewhere in between so that no one feels like they're totally losing. So if we're close, let's go for a mediator's proposal. The other thing I want to emphasize about deal making is in a lot of these types of litigation, even when it's over, you're going to have some sort of relationship with the other side. If you're getting a divorce and you've got children, your kiddos may be 3 years old, but 20 years from now, they're going to get married and you're going to go to the wedding, and so is your ex-spouse. 30 years from now, they're going to have children. You're going to be a grandparent and your ex-spouse is going to be a grandparent, and they're going to be at the hospital. So when you come to mediation, this is not all about winning. Think about, is there some value in preserving that relationship? You may not love them anymore. You may not live in the same house with them anymore, but they're going to be in your life. If you're a business dissolution and you and your business partner are selling a business, it's not usually over with the snap of the fingers. We're going to have to sell some assets. We're going to be changing over some documents. There's some value in preserving at least a little bit of that relationship just so you can communicate and get all the details worked out. The other thing about I'm going to beg you to reach an agreement is because I find that when people reach an agreement versus going to court, when you reach an agreement, you've been involved in that process. You've had input, you've made suggestions, you've had requests, you had a proposal. Most people, if they reach an agreement and they've invested in that agreement, both sides, you and the other side, are more apt to honor the agreement. Okay? You go to trial and some judge, a jury, makes a decision. They put a valuation on the business. They decide who gets the farm. They decide what's the value of the farm. They're usually going to decide against one party and for the other party. Whoever they decide against is not going to handle that decision easily. There's still going to be a lot of anger in them, and they're going to do everything they can to try to defeat that decision, whether it be an appeal or try to thwart the decision, whatever it may be. And so therefore, you're better off reaching an agreement, because if we reach an agreement and we're dividing assets in a divorce, we're dividing assets in probate, we're paying child support, we're dividing a business, we're making payments each month to a former business partner to buy out, most people will honor that agreement much more. They'll respect it if it's an agreement that they participated in. If some judge says you're going to make payments to your ex-business partner, it's just not as easy to swallow. So for all these reasons, for the emotional, the financial, the risk aversion, look, for all these reasons, I'm going to encourage you to go to mediation and reach an agreement that you participate in, that you approve, and that you sign. It's going to be much better for you, for your family, for your business, for all aspects of your life, rather than going to trial and having a judge or jury decide it. It's usually a lot cheaper, too. Well, I hope you've enjoyed this. I hope this helps. And in fact, that's the reason I'm doing this. That's the reason I mediate. That's the reason I make these videos out of my own pocket, is to help you. A lot of you I know, lawyers I work with every day, I like and respect. Some of you I have not met yet, but I want you to know I like you and I hope this helps you. I've enjoyed this time together, and I want to thank my video professional and producer, Phil. Phil's a great guy. If you think this quality video, you contact me and I'll connect you with Phil. He can do one for you. You have a great day. God bless.